Hi, Salma. I think we're about ready to get started if you'd like to kick us off.
Sure. Aloha. It's so nice to see so many familiar faces. Thank you for spending some of your afternoon with us at the ACLU of Hawaii. I am blessed to be the executive director of this organization with amazing legal activists, including Leilani and our legal director, Wookie Kim, and Emily Hills, our senior staff attorney. And for those of you who aren't familiar with the ACLU's work and what we do locally, think of us sort of as an integrated advocacy organization. We have three main sectors. One is our legal department that works on litigation. Then is our policy department that works on legislation. And lastly is our community engagement department that works on public education. Lani is our first kind of specific expert-oriented hire that's working across all three of these. She is doing these habeas petitions that she's going to train us all on today, as well as submitting testimony in the legislature for different reform that we can envision here locally to protect immigrant rights. And she's been leading Know Your Rights workshops. Yeah, so excited to get started in this training today, particularly in this moment of government backsliding. Particularly, we know that immigrants are sort of at this moment the target of the federal government in such severe ways. And so, thank you all so much for being here and to learning about just the unlawful detentions that are happening across our islands and how we can all volunteer with just a little bit of our time to make a substantive change. And without further ado, I am really honored to welcome Wookie, our star legal litigation director here at the affiliate. Thanks so much.
Thank you, Selma. And I just wanted to start by thanking everyone for joining today's call. My understanding is that we have a pretty diverse group of participants. We've got budding law students, we've got current immigration lawyers, we've got folks who have experience in federal court but haven't ever done immigration habeas. Yeah, really excited to start the conversation today because, this issue is one of the issues that is really impacting Hawaii, right? The way in which the current administration has been trampling on people's rights, in particular, people who are immigrants, has been extremely problematic. And we've seen ourselves kind of the way in which immigrant detainees are taking up a much larger share of the federal detention center population in recent weeks and months. And as Salma alluded to, we filed the first of what we hope will be many habeas petitions on behalf of an immigrant detainee. We know that there are well, maybe not many, but we know that there are other Hawaii practitioners who are already doing this, and we thought it would be a great opportunity to train other people up and also open up a dialogue. We also wanted to thank Dan McFadden, who's, I just learned, a former Hawaii resident. I don't know why you've never shared that fact with me before. He is managing attorney at the ACLU of Massachusetts and has been leading their kind of regional habeas project. And so we're really thrilled to have him present today. And then, of course, we have Leilani, who, as Salma already mentioned, is our immigrants' rights attorney and really is spearheading our rights work here. So without further ado, I will pass things off to Leilani and Dan to go ahead with their presentation.
Great. I'm going to go ahead and share my slides, and we'll go ahead and get started. Great. Can I get a thumbs up if folks are seeing the screen all right? Great. Thanks so much, Dan, again for being here, and thank you all for joining us today. As was mentioned, I'm Leilani. I use she, her pronouns, and I'm the immigrants' rights attorney here at the ACLU of Hawaii. As some context, as Salma mentioned, and I'm sure most of you are familiar, just a little bit of an overview of what the ACLU of Hawaii does. We are a nonprofit, nonpartisan civil rights and civil liberties watchdog. And so we do a lot of work across litigation, policy, and organizing. And part of what brought you all today is probably your awareness of the litigation work we do. And here at the ACLU of Hawaii, we're starting to focus more on immigrants' rights. And so we're really excited to be moving into this area in partnership with so many private attorneys who already work in this area, as well as nonprofits and community advocates as well. So today, just a little bit of context about what we're going to talk about, and maybe also just a warning about what we're not going to do. Today, we're just going to go over briefly what immigration detention looks like here in Hawaii, the stats on increases in detention, as well as where folks are located if they are arrested and locked up for civil immigration violations. Second, we'll talk generally about what a habeas petition is, what that means, where you file it. And primarily, we'll be focusing today on what are common immigration habeas fact patterns. How can you issue spot if you work with an immigration client? For sort of what are the different bases you could be bringing an immigration habeas under. We'll go over a few of the basics for filing such a petition in federal court, leave you with some resources and a good amount of time for Q&A. And just as a caveat, today we're going to be talking a lot about generalized fact patterns, issue areas that might come up. We can't give individualized, determinations on this is exactly what this client would need for their habeas. But there are so many amazing resource banks of template habeases that are out there in today's day and age. And you're welcome to reach out to us as well as refer different cases to our office if a habeas petition is something you think your client might be eligible for. So, jumping right in, why are we here today? Because we're seeing a huge increase, even here in our islands, of immigration arrests and detention. And so what that means is that folks who are typically going through immigration court proceedings, who usually just went into different ICE check-ins, but were living and working in the community, are now being picked up and locked up for months on end while they're going through their removal proceedings or even after they have an order of removal. And so based on some statistics provided from the federal government and civil beats analysis, we've seen an increase in arrests from 194 compared to 52 in the prior time period. And on any given day, there are about 80 detainees at the Honolulu Federal Detention Center. And that's where folks are held. You might be familiar with the Honolulu Federal Detention Center. It's right next to the Honolulu Airport, and it's where folks who are typically accused of federal crimes are held pre-trial. For our federal court practitioners and sort of attorneys who might not practice in immigration super often, just want to give you a few background pieces of information so this doesn't all look like alphabet soup when we start rattling off statutes and agencies. I know for immigration practitioners, you might just want to bear with me, grab a snack. So just going over basically at the federal level, there are civil statutes called the Immigration and Nationality Act of 1952, and that's called the INA that governs civil immigration here in the US. For my immigration court practitioners, you are probably most familiar with the INA citations, as we'll get into when you're practicing in federal court or if you're assisting a federal court practitioner. Federal courts like to see the 28 USC code citation, not the INA, because they are also often not familiar with immigration court proceedings. So just so you're aware, same thing, but just sort of a different language or a different citation that you'll have to plug in. Who operates and who sort of controls and runs immigration? It's the Department of Homeland Security, often known as DHS. And this was sort of a consolidation that happened in the early 2000s to sort of centralize all different immigration enforcement and proceedings under the same department. And so under that department, there's a few different branches: the U.S. Customs and Border Protection, CBP, U.S. Citizenship and Immigration Services, USCIS, and ICE, U.S. Immigration and Customs Enforcement. So typically, affirmative applications for gaining legal status or citizenship happen through USCIS. And defensive applications will happen in immigration court. And for context, immigration court is an Article 1 court, so not Article 3. So kind of falls under that executive branch. Um, and so we're going to be talking primarily today about non-citizens who are already inside the US. There are different procedures and applications of immigration law for folks who are applying to enter from outside. But today we're going to be focusing on folks who are already in the country and who have been detained. And so we'll use the word removal proceedings, and that means and is referring to non-citizens who are in the US that are placed in removal proceedings if ICE charges them with being inadmissible or deportable. So again, just a little bit more context on what these words might mean. And if you're just sort of familiar with like colloquially, we just talk about deportation. There's a little bit of a nuance in language that applies to non-citizens. So you might see the word inadmissibility thrown around, and what are grounds of inadmissibility? Those apply to people who are trying to legally enter the US or who have entered without proper legal immigration status and were not inspected at the border. So some examples include folks who have been convicted of certain crimes, those who might not have a valid visa or legal permission to enter the US, or those who entered without permission. And so a non-citizen who comes within one of these grounds of inadmissibility will be called inadmissible. Similarly, for folks who are non-citizens who have already been admitted to the US on a temporary or permanent basis, so think of someone who came in with a student visa, a work visa, etc. Those folks might be subject to different grounds of deportability. So some examples include, again, being convicted of certain crimes, maybe falsely claiming to be a US citizen, whether intentionally or perhaps by accident. And another ground of deportability, or the ability to remove someone from the country, would be if that person was inadmissible at the time that they were admitted to the US. So now that you have a little bit of background or about who might be subject to an arrest or, subject to removal, Dan is going to go over a little bit about where immigration arrests are happening.
Sure. And hi, everybody. My name is Dan McFadden, and as Wookie mentioned, I'm a managing attorney here at the ACLU of Massachusetts. Also, was very fortunate to live in Hawaii for a few years now, many years ago. I was thinking back on that time with particular fondness yesterday as I shoveled the 2 feet of snow that we got here, which I imagine you don't have there. But I'm really glad to be speaking with you today about immigration detention and immigration habeas work. I've been doing this work now for about 15 years in different ways. It used to be relatively uncommon to bring a habeas petition. Usually it was when something very unusual happened. A person's detention somehow became very unusually prolonged or something like that. And sadly, with the very aggressive enforcement happening right now by the second Trump administration, immigration habeas has become a very active part of our docket here in Massachusetts and in many other places. There are literally in some districts like hundreds of cases being filed every month as a result of the very aggressive detention work that the ICE is currently doing. And we're seeing that detention work play out in a number of different ways. We see a number of community arrests. Sometimes these can be in the home. ICE may show up at a person's house and ask for permission to enter. They also are now asserting that if a person has a final order of removal, that they can enter involuntarily without a judicial warrant, which is a new practice, which we think is unconstitutional and raises some really grave concerns about the Fourth Amendment. And then we also see a lot of vehicle-based arrests. So we think that ICE has access to vehicle registration databases, for example. And so when they have a person who they're targeting, it appears that in some cases they can identify which vehicle that person might be in and stop the vehicle. We often see a lot of force used when those vehicles are stopped. So, for example, smashing windows of vehicles in order to extract people from the vehicle, things like that. We have a client currently who was actually strangled unconscious inside of his vehicle by an ICE agent during a vehicle stop. So it's been very aggressive enforcement on the vehicle side. And then we also see at the immigration court in places like New York, particularly, ICE has been very aggressive about arresting people as they leave or enter the immigration courts in some cases. Often the government will try to dismiss the immigration case and then they'll rearrest them in the courthouse, in the hallway or in the elevator. So we've seen um, very frequent enforcement in those contexts. When that happens, we also see what are called collateral arrests. So a collateral arrest in ICE terminology is when they're targeting person A and they go to arrest that person and some other person, B, C, and D, they're also present. And ICE may choose to arrest them as well if they determine that they think the person doesn't have status. So that can mean, for example, a family member in a car, or it could mean other people at the scene of some other enforcement action. And ICE asserts the ability to conduct those arrests, basically when they've encountered a person and they think that there's reasonable suspicion or probable cause that they don't have permission to be in the country. So both the target and people with the target, coworkers, for example, may be arrested. And then we also see enforcement in other places. So in our criminal courts here in Massachusetts, for example, ICE will frequently follow people to or from the criminal court and try to arrest them when they're going to or from court, when they have some type of criminal hearing. And we also see enforcement at the airport. Um, Not typically domestic flights, although we have seen some of that. There was recently a woman here in Massachusetts who was a student in Massachusetts whose family was in Texas. She was arrested on a domestic flight from Massachusetts to Texas. She had a final order of removal. But that's not frequent. Mostly at the airport, it's in the international section of the airport when people are arriving or leaving the country. Um, U.S. citizens, typically, if they're stopped, it's obviously not going to be for civil immigration enforcement. But in those cases, it may be for something like a device search. ICE and CBP assert the ability to conduct searches of electronic devices at the border with very little cause. And they also, of course, if they determine the person's engaging in criminal activity, they're crossing the border, for example, they're smuggling narcotics or something, they may conduct an arrest as well of a U.S. citizen. But the airport enforcement that we see on the civil immigration side is typically one of two things. One is that returning lawful permanent residents need to be careful because when a lawful permanent resident is returning, typically they are not treated in the same way as another non-citizen who's arriving in the country, and that they don't go through the same screening. But there are certain grounds of inadmissibility that can be applied to them at that time. And so we've seen people, for example, who have very old, very minor criminal convictions, who have been a lawful permanent resident inside the United States for decades. And those convictions were so minor that they could not trigger removal proceedings. But when they're coming back in from traveling abroad to see family, they can trigger an inadmissibility inquiry at the time of reentry. And CBP has been very aggressive about doing that. So people with like old marijuana convictions, old shoplifting convictions, stuff like that, who are re-entering LPRs are being detained and treated as mandatory detainees. And then we also see people who have visas who are coming in who are being subjected to very aggressive inadmissibility screenings, often involving looking at photos or other documentation on their phone to try and determine if they fit some inadmissibility criteria. For example, is there something in there that might suggest, that they have an intent to stay in the United States to work rather than visit if they're coming on a visitor visa, things like that. So we see enforcement in all of these different contexts, and it's been quite active. The process after arrest by ICE is not that different in some ways than what would happen in the criminal system, but it's also not the same either. Typically, people are taken to a booking location, much as would happen in the criminal system. But what we see, at least here in Massachusetts, and I'm a lawyer in Massachusetts, I'm practicing the First Circuit, so I don't know all of the details of what's happening in Hawaii. But what we see here in Massachusetts is once they go to the processing facility for booking, um, typically, they're not provided with a lawyer or often any access to any outside communication during that time. Uh, and they're certainly not read any Miranda rights. And they are interviewed typically for preparation of essentially the equivalent of an arrest report, which is called an I-213 in the immigration system. And so all that will happen during the booking process. And then they will typically go to a detention facility if ICE determines to detain them. And the length of time they spend in that detention facility may vary because ICE very often transfers people from one location to another. Um, ICE maintains essentially that once they've arrested you, they're under no obligation to hold you in the state or district where they arrested you. So we often see in Massachusetts, for example, people might be transferred to other New England locations like New Hampshire or Rhode Island, but also in many cases they're getting transferred to very distant locations like Texas, Louisiana, New Mexico, places like that. And those transfers, of course, can be very difficult for people. They're separated from their counsel, their family, all of their resources, and the detention conditions can often be a lot worse in the place that they're going to. Um, so that can be quite difficult. CBP arrests at the airports are a little different. Oftentimes, people are being held in what's called secondary screening, which is like an interview room type location within the airport. And we've seen people held there for very lengthy periods of time sometimes while CBP makes a determination, sometimes as much as 3 or 4 days. And they may not have access to healthcare, medications, food, sleeping facilities, sanitary facilities, all that kind of stuff during that time. So that can be um, quite difficult. And then the um, authorities for detention are going to vary, and we'll talk about these in more detail. But basically, there's something called 1226, and that's a statute that historically, dating back to the mid 90s when this statutory regime was created, historically 1226 was basically people arrested inside the United States were going to be in the 1226 category, either permissive detention, which is people without certain types of criminal history, and then people with certain types of criminal history would get mandatory detention. Excuse me. And then separately, there's 1225, which historically was people who were arriving or had very recently arrived in the United States. And then 1231, that's a person who's actually gone through the entire removal proceeding process in the immigration court, exhausted all their appeals, and they have a final order of removal. And that's a detention authority for folks in that category.
And I'll just add a little bit of context for Hawaii. Most of the booking and processing is often happening directly at FDC Honolulu. It's possible that if there were initial arrests on neighbor islands, there's some holding briefly with local county police departments, but then the transfer here to Honolulu happens pretty quickly. And mostly we're just seeing detention of folks who are from any of the islands here in Honolulu stay here. With a few exceptions, we have seen a few folks who are from the continent, California, Florida, brought here for detention, and that's really difficult because they might not have any ties here and are trying to contact a local attorney, which is different than their immigration attorney, who might be Dan, way out in Massachusetts or something like that. And sort of similarly, another scenario where we would see folks from Hawaii and Honolulu FDC being shipped to the continent is if ICE determines that that person should be removed to a third country. So I'm sure you've heard in the news of folks being shipped off to countries where they have no ties at all, just to be removed because that's the administration's new priority. And so then at that point, we could see a pretty rapid transfer out of the state. And that can be really challenging and difficult at that point to find local counsel on the continent.
And we'll touch on this more later, but one of the things that the Trump administration is doing right now is they are trying to reduce the opportunities for people to be released after they get arrested and brought into civil immigration detention. And the way they're doing that is by misclassifying people who, for the last 30 years, have been understood to be 1226A detainees who can potentially be released after they have what's called a bond hearing. Essentially, it's a detention hearing that they receive in the immigration court. And they're misclassifying those and moving them from 1226 over to 1225 B2, which is a mandatory detention statute that historically has applied to people who are being arrested as they're in the process of entering into the United States. That shift has been really significant, and they're doing it for basically everyone who entered originally without inspection and then is later arrested inside the country. And it means that a very large percentage of people who previously were folks who might get released through the immigration court process, through the bond hearing, are losing access to that bond hearing. And now they need to go to the habeas petition route because that's the only way that they can potentially secure release because the administrative route is being cut off. So we can talk about that more as we go forward. Um, in the immigration court, um, the cases are divided up by whether or not the person is detained, and the way they have a detained docket and a non-detained docket. Detained docket cases are generally on a more accelerated schedule. Non-detained docket, for example, here in Massachusetts, they're scheduling hearings out in like 2028. Whereas on the detained docket, it's often, within a month or two, you're moving forward through the hearing process. And that can be either good or bad. I think, on the whole, they say, well, if you're detained, you should go faster. But of course, also it can be disadvantageous for a lot of reasons to go fast, especially if you're detained and you don't have the ability to gather any evidence for your case, for example. You don't have the ability to work to pay your lawyer. There's all kinds of disadvantages to being detained that are quite difficult for people. Um, the When a person gets a bond hearing, the bond hearing record and the record of the main proceedings are actually kept separate. They're sort of treated like two separate proceedings, which is helpful in some ways in that bond hearing information doesn't necessarily cross-pollinate over into the merits hearing. Um, and I think this is really important. So often when a person gets arrested, what's called a notice to appear, which is the civil charging document for civil immigration proceedings, the notice to appear, or NTA, is generated at the time of arrest. But the immigration proceeding in the immigration court doesn't actually begin until ICE files that NTA with the immigration court. That can often take a long time. We've seen to a month for them to do that. In the meantime, the person's being detained without charge. But you don't have to wait for them to file the charging document to ask for a bond hearing. There's a regulation that allows you to specifically request the bond hearing as soon as you're detained, without waiting for the NTA to actually get filed and start the formal proceeding. So that's very important, I think. So these delays on the part of ICE in creating this document or filing it to initiate the proceeding shouldn't stop a bond hearing in the immigration court. When a bond hearing in the immigration court occurs, and a lot of habeas petitions right now, the goal of the petition is to get to a bond hearing because these are one of the things that are being denied to people. Um, the bond hearing is similar to a detention hearing in some ways that you might have in another court system. The rules of evidence don't strictly apply. Oftentimes, documents like police reports can come in for the truth of matters asserted in the police reports, even though they wouldn't, strictly meet the federal rules of evidence. Um, and the standard and burdens of proof uh, it can vary. Typically, in the First Circuit here, we've got some case law that requires the government to bear the burden to prove a reason to keep the person detained, either flight risk or dangerousness. In most other places, and I believe in the Ninth Circuit, this is true for most bond hearings, the burden would be on the individual to prove that they're not dangerous or not a flight risk in these hearings. And then just lastly, you might hear about a Joseph hearing. Joseph hearing is a special kind of hearing that precedes a bond hearing. So if the government says you're not entitled to a bond hearing because, for example, you're a mandatory detainee based on criminal history, if you dispute that, you can get what's called a Joseph hearing, which is basically a hearing about whether you will get a bond hearing. And that is also in the immigration court potentially.
Dan, just for like any federal court practitioners who might be wondering, like, what's a bond hearing or like why would someone need that? Can you explain sort of like what would happen in a maybe normal administration and then just like why that's increasingly common or necessary now?
Yeah, I mean, so normally the way it's worked for 30 years is if you get arrested inside the United States, typically you're a 1226 detainee, and most folks are 1226A detainees who are eligible for release. So they would go into a bond hearing in the immigration court, and there would be an assessment of their whether or not they're dangerous or they're a risk of flight. The immigration court, much like a detention hearing in a criminal case, can set conditions. It can order a bail payment, and then the person would be released, assuming that they're not found to be so dangerous or such a high risk of flight that those, conditions or combination of conditions are insufficient to assure their appearance and the safety of the community. So that's how it normally works. And under that system, many people would very regularly get released from immigration custody after arrest. Under the current administration, because the Trump administration has now misclassified a huge group of those folks as mandatory detainees under a different statute, people aren't getting into the bond hearing at all. What will happen is they'll ask for a bond hearing, they show up, and the immigration judge will say, "No jurisdiction, I can't hear your bond hearing." And then they have to go to habeas to get a federal court order for the immigration court to conduct the bond hearing, basically. And so that's why habeas is so intertwined now with the bond hearing process, because the habeas petition is how, in many cases, people access the bond hearing in the first place.
Great. Thanks so much for that context. And I think just jumping now into habeas, what it is. As I mentioned, this training will focus on teaching context and concepts, not particular cases or applied to individualized facts. But at the same time, as I mentioned, we're going to go over sort of big buckets of kinds of habeas petitions that are being brought really frequently right now. I think the great news is there are so many templates that are out there. And immigration habeas is also a really flexible sort of area for exploration or new ideas, good faith challenges to existing law, because a lot of the challenges are saying, hey, this is unlawful detention. Maybe there's a violation of an immigration statute or regulation, like ICE didn't go through the right procedures in detaining someone or re-detaining someone who might be out on an order of supervision. And there's also just a variety of due process challenges that are brought. In the Ninth Circuit, there's a lot of messy and complicated case law around prolonged detention, when you're still in removal proceedings or post-final order of removal. And so there's really a lot of gray area, and that's a great basis to try and get someone out. At the same time, we have to remember our Rule 11 standards. So a habeas petition can be, relatively brief, especially if you're filing really quickly. If you know someone is likely to be moved to the continent or removed from the country really soon, it's okay to file something that's, a little bit more bare bones. It doesn't need to be a full legal brief, but at the same time, you want to make sure that you can articulate a proper Rule 11 basis based on the facts that your client has told you, based on other similar cases and case law that you might see. And the great news is that because we're in the Ninth Circuit, there's a lot of very recent cases since January 2025 that have been filed in Washington, California, Arizona, where there are really big detained dockets. And so almost every fact pattern you can think of, probably a court has seen it in the past year. And so those are really good starting points. So what is habeas? I think we've probably heard this word thrown around. If you're familiar with criminal defense, you know that it literally means to produce the body, or you have the body. And it's something that's built into the Constitution. So before the Bill of Rights, it's really enshrined that the writ can't be suspended except for in unusual circumstances. And while these are unusual times in some ways, we're not there yet. Habeas is very much alive and being utilized in really unique ways and at a scale that we haven't seen, I think, in decades or maybe ever. And so it's a common law roots as a means to just challenge unlawful detention. Um, and it applies really great in these cases of non-criminal or civil detention as well. And it's usually described as an equitable or adaptable remedy. There's a few different kinds of habeas petitions that can be brought. So most commonly, you might be familiar with post-conviction habeas petitions. So folks who have been convicted of federal or state crimes can bring, that's sort of your straight up habeas petition that you might think of colloquially. But what we're going to be focusing on and what immigration habeas petitions fall under is 28 USC 2241. And specifically, you're challenging that the detention is in violation of the Constitution or federal law. And so again, the INA, federal statutes, or the Constitution, due process, Fifth Amendment rights. And so again, we'll go over the different bases, but sort of generally speaking, habeas petitions for immigration purposes are now being used to challenge prolonged detentions. So think 6 months, several years. Third country removals to, maybe a client has been granted withholding of removal to one country, but then ICE is trying to deport them to another. And then, challenging other sorts of unconstitutional detentions that weren't in compliance with regulations or with certain procedures that they should have been entitled to. And again, denial of a bond hearing or a bond hearing that wasn't held under the appropriate burden of proof or in the right manner is also sort of an increasing basis for bringing habeas petitions. So the rules that govern habeas are here in Hawaii, Local Rule 99.3 states that all federal and local rules apply to habeas petitions that fall under 2241. So that's us. So that governs, just your typical formatting in federal court and that sort of thing. But what's different about habeas and pretty unique from how a civil case might proceed is they happen and the schedule of proceedings will happen much more expeditiously. And that's because under 28 USC 2243, federal courts have the authority to issue a writ or order to show cause, meaning the government needs to respond in some way within 3 days or a time not to exceed 20 days. And I can talk about this a little bit more, but typically here in Hawaii, what we're seeing from the district court judges is a status conference that's set pretty quick just to set up a briefing schedule. So, the court will work with you, or you might be able to work with the U.S. attorney on what an appropriate timeline might be based on the urgency of your client needing to get out of detention. So generally, again, they'll move at a much quicker basis, like maybe a hearing within 2 weeks, not 2 months or 2 years, like you might be a little bit more used to if you're filing a summary judgment for a typical civil case. There isn't a lot of discovery that usually needs to happen. There is some that can occur when you file your petition. It can be pretty bare bones, maybe a few exhibits, and then the government might return with a lot more documentation from the immigration court proceedings. But typically, you won't need depositions or too much evidentiary development unless, can vary case to case. But a lot is just sort of based on straight up, legal arguments and development and application of due process violations in the context of a particular case. And so habeas procedures are flexible, but broadly conform to the civil rules. A notable exception is service. And so one way to sort of initiate or to ensure that you've completed service is just to follow Federal Rule of Civil Procedure 4I, which goes through how you serve the United States and its agencies, since the respondents will typically all be federal employees in this context. But what we've also seen here in the District of Hawaii is that after a habeas petition for immigration is served and filed with the court, often the court will just order service in a particular manner. And that manner has typically looked like emailing the local U.S. Attorney's office and maybe dropping off a copy. And then the court will say that's enough for service. In other cases, like in the case that we had filed recently, we had to go through a little bit more of a typical service procedure. Throw it back to you, Dan, for formulating an immigration habeas.
Sure. So when a case comes in that's a potential habeas case, there's a few steps that you have to go through in order to identify what is the claim that I'm going to bring, if any, on behalf of this person. So one is you have to figure out what is the nature of the proceeding that this person is in or maybe has already completed. Are they in an ongoing removal proceeding? Do they already have an order of removal? Have they just arrived and they're detained, upon arrival? Are they in something called expedited removal, which for a small category of people means they can be sort of summarily removed from the country? And then the government has also asserted something called the Alien Enemies Act against certain folks from Venezuela, which it's a whole separate conversation, but that's also out there. And then you have to think about, once I've identified the nature of what's happening to the person, what are the claims that I might bring about why that's wrong? And that might be that they're entitled to a bond hearing, but they're not getting one. It might be that they went to the bond hearing and it was conducted improperly in some way. It might be that the detention has become very prolonged. It might be that the detention that the person had been out on some type of release status and they were redetained for without proper procedures or without a change in circumstances that would justify redetention. And sometimes also you can have sort of due process Eighth Amendment type humanitarian claims, if the person, for example, has a very serious medical condition where being detained is inherently unsafe for them. That might be a Fifth Amendment or Eighth Amendment type due process claim. So I think once you've started that process, we can go to the next slide. Really the first thing to do as you're, oh, I'm sorry, there's a question.
Sorry, thank you for taking my question. I was just wondering, the 6 months, when do you start counting the 6 months for the Zydvitas clock?
That's a great question. So that 6 months is for those who haven't done Zydvitas things before. Zydvitas is a case that says after you get a removal order, if the government detains you for 6 months and hasn't managed to actually deport you, then presumptively that detention is going to be unreasonable and you should be released. And there's always a question, when do you begin counting that 6 months? If it's a continuous period of detention, you would count it from the time the order became final, and then it would go from there. The disagreements tend to arise if it's been broken up in some way. So sometimes a person will get the final order, they won't be able to deport them, they'll release them on an order of supervision, and then they'll be redetained. And the question always becomes, do you count the prior period of detention as well and add it up with the current period of detention, or just the current period of detention? We always contend you should accumulate everything and aggregate it so that it all adds up together. The government typically contends that you should only look at the most recent period of detention, and that's usually a fight that has to happen before the court.
It's really helpful. Thank you. What protections are there for detainees who have been detained for a really long time before they even get their removal hearing? Is habeas a possibility in that circumstance?
Yeah, and we'll talk about, I think, some of those potential claims as we go forward. But yes, there can be claims based on prolonged detention for sure. So I think the first step as you're evaluating something like that is to figure out what is the current detention authority that the government is asserting. As we talked about, there's really three categories that typically would be asserted. And so you have to try to understand what is it that they're claiming is the basis for detention. They won't generally tell you. So you may have to be a little bit of a detective and try to figure out what is most likely the detention authority they're going to claim. And then, just keep in mind that whatever they're doing, it has to match up with the constitutionally permissible purposes of detention, which is, ensuring appearance at the proceeding and public safety, right? Protection against danger. And so there's always potential claims if what they're doing bears no relationship to any of those objectives.
Great. And so we're going to start jumping into these sort of three categories, starting with Section 1226. So again, historically, this is what most folks would have fallen under when they're initially detained. 1226A authorizes discretionary detention, and is sort of the baseline rule, which authorizes release on bond or certain conditions that are applied after that bond hearing. So again, ICE would make the initial custody determination at the arrest. A detainee could request a redetermination if, they're subject to detainment after that. And that's the bond hearing by an immigration judge that we've been talking about. The other section that's key under 1226C is mandatory detention. And so that's for folks who were convicted of or admitted to certain crimes. And that would typically mean that that person is not entitled to a bond hearing and sort of subject to detention without too many flexible arrangements or redeterminations for custody off the bat, at least. And in 2025, there was a new act passed called the Lake and Riley Act, which sort of expanded potentially the class of people who should be subject to 1226C now, though I know there's some ongoing litigation that Dan is familiar with that's sort of challenging that new basis. But just generally, 1226, we have A, discretionary detention for folks who haven't committed crimes. 1226C would typically for those who do have some sort of criminal history with specific provisions. And so there are sort of different bases for habeas claims to consider under each of these. Again, we'll be sharing these slides, so I know there's a lot of different bullet points that we'll go over. But commonly then, 1226A, because that's the discretionary basis, if a person who is detained under 1226A didn't get a bond hearing to begin with, um, and is being allegedly classified under 1225B2, which is a matter of Yohuri Hurtado issue, or just some other reason they weren't given a bond hearing off the bat. That's something that is a clear basis for habeas to just get that bond hearing that they're entitled to at the start of detention. A bond hearing might be delayed as well. Or again, there's not proper procedure that's followed because the burden of proof was improperly shifted, or the immigration court judge didn't consider alternatives to detention. Um, Dan, do you want to talk a little bit about automatic stays that are happening? I don't think we've seen them too often here, but just like want to.
Yeah. Yeah, the automatic stay is a regulation that DHS created um, that says that if they don't like the outcome of the bond hearing, they just will ignore it for up to 150 days with no additional process. We actually have appellate advocacy happening right now in the First Circuit on this question. It seems like a pretty clear due process violation. They don't assert it in a lot of cases, but when it does come up, it's obviously very hard on the person because they'll try to pay the bond and they'll be told they can't. So if the automatic stay comes up for sure, that is a potential claim.
Great. And then under 1226C, there's more limited bases for habeas just because mandatory detention applies. But there's still some potential for prolonged detention claims if, detention during removal proceedings is exceeding, maybe a year more than that. Those are definitely starting to become ripe for a prolonged detention claim. And other sort of constitutional challenges remain, as we mentioned, sort of if there's really extreme medical conditions that folks have and would require some sort of release. Anything else you want to add, Dan, on this page?
No, that's great.
Great. Pass it over to you.
Sure. Yeah. So the 1225 INA 235, that is a mandatory detention historically applied to people who are just arriving in the United States. In immigration law, there's generally a distinction between people who've already entered versus people just arriving. That is based in part on due process principles that people inside the United States have due process rights that people who have not yet entered or at the threshold might not have. And so 1225 is basically a mandatory detention statute that historically has been about people arriving in the country. And there is a potential for release. It's not via a bond hearing, but there is a discretionary release authority in certain humanitarian circumstances. So there's different claims that can be considered. One of them is, they might use expedited removal, which is a subset of 1225 that allows for much faster and essentially due process-free deportation. There are particular claims that can arise if they try to do that, if the person's not actually eligible for that. And then there's a variety of other potential claims that can come up, particularly where they're saying somebody is 1225 when actually they were arrested inside the United States. Our contention has been those people are actually 1226. And there's a whole there's actually several hundred cases on that have been litigated in the last 3 months or so, including multiple class actions. There's now a number of nationwide judgments, so it's getting kind of complicated. Two circuits have weighed in now, and so I won't go into all that right now. But that misclassification issue has been very active and a very significant issue for anyone who's arrested inside the United States and had not originally entered with permission. And yeah, so I won't, go through all these, but basically there are these potential challenges to expedited removal. And there may also be other potential challenges like as applied constitutional challenges, if the basis for detention is a conviction that's so old and so minor, that it really has no possible bearing on anything, that there might be like a as applied substantive or substantive due process type challenge there as well. 1231 This is for people who have the final order of removal, meaning they got through the immigration court, they got ordered removed, they've exhausted any appeals, and they have an appeal automatically available to the what's called the BIA. At least if for a few more weeks that may go away, but they can potentially appeal to the BIA, which is an administrative appeal, and then they can go to the Circuit Court of Appeals in some cases as well. After that, they're in what's called final order of removal detention, 1231 detention. There's a mandatory period of 90 days after the order becomes final, and then it becomes discretionary if they can't effectuate deportation within 90 days.
And just sort
And
of on that, oh, go for it.
oh, go ahead.
No. I think Dan has already sort of just mentioned Zedvitas would apply, and Zedvitas habeas claim would sort of apply typically when someone has been detained for more than 6 months after detention, or after the final order of removal is final. And so that also applies in cases where removal is no longer reasonably foreseeable, and something that we might see a little bit more commonly in our islands are folks who are former refugees or LPRs from Vietnam or Cambodia or Southeast Asia, who have had criminal convictions and therefore, might no longer have a pathway to status or have had that status revoked. But there's really no reasonable possibility of them being removed back to those countries that they came to as children. And historically, those countries have not wanted to issue documents for them to, so they kind of become stateless. So that's a potential fact pattern that we would see here in Hawaii a little bit more commonly. And then there are other sort of post-removal period claims that would apply where custody reviews aren't being required or aren't being followed by the regulations. So there's sort of the 90-day custodial review, 180-day custodial review. Frankly, those are definitely being delayed and probably ignored a little bit more than they would in normal circumstances. So we might start to see sort of detention time just increasing and increasing. This was me or you. But yeah, other sorts of claims, a little bit more specific, but might have to do with any sort of medical impacts of detention, again, due process issues, redetention without a pre-deprivation hearing or a change in circumstances. So again, folks who are on some sort of order of supervision who are already checking in regularly and then just get scooped up instead when there's no material change in their circumstances. And if there's any other conditions that would feel like custody or sort of feel like detention that are imposed by ICE that weren't included in an immigration judge's initial bond order. Those are a little bit less common. We can talk through in Q&A sort of other fact patterns that wouldn't fall under sort of your 1225, 1226, 1231. I know we're getting close on time, but we're going to finish up our substantive comments in just a few minutes. And then if folks want to hang around or if you want to jump because it's the end of your lunch hour, totally understand. But just briefly going to go over remedies in habeas and sort of basics on filing one. So remedies in habeas are generally related to release, right? We want to get folks out of detention. That doesn't mean it's going to have an impact on their immigration court proceedings, but it allows them to be working, living, receiving medical care in the community while they're still going through those. And so typically in your request for relief, you're seeking release outright. Or sometimes, again, you're seeking a bond hearing, maybe with specific instructions to the immigration court about how to conduct that bond hearing to make sure it complies with the right burden of proof, et cetera. And in certain circumstances, a request for the federal court to do the bond hearing could be possible, or the federal court requesting that the federal court order release if a bond hearing isn't held within a particular amount of time. And something that we have included in our habeas petition or that courts here in the district are doing sort of on their own accord is requesting that folks are not moved out of the district while the petition is pending. Because if you file a petition and then all of a sudden that person is shipped to California or elsewhere on the continent, habeas petitions typically have to be filed where the person is. And so that can really start to mess things up if they're moved to a different state. just some basics on filing a habeas if you're thinking like you're ready after this training, or you are a federal court practitioner and you want to eventually partner up with some immigration court practitioners. The great news is it's only a $5 filing fee. So not the typical sort of $400 plus filing fee that you would associate with a civil action. And you're filing it in the federal district court for the District of Hawaii, which means that you do have to be barred here in Hawaii and admitted to the district court here. The venue, again, is where the individual is at the time of filing. So for anyone here at Honolulu FDC, it's here, and that's why it's so important to request that during the pendency of the petition, that person is not removed to a different detention center. The parties are the petitioner, which is just the word used for the person who's detained. And then the respondents will be the Secretary of DHS, the U.S. Attorney General, the Warden of FDC Honolulu, since that is the person's immediate custodian, and then also the ICE Field Office Director for the San Francisco Removal Office. And we have their names listed here, and their addresses are available publicly. Just briefly on how to file, again, you would initiate a case through ECF like you typically do, but you would file it under a habeas action. All you need is the petition, but you can include legal argument in that. You can also attach some exhibits that you think if they're necessary. Or you can file a really brief petition and attach a separate brief. We've seen it done both ways in this district. Again, service we went over. The court will often issue an entering order directing service to the local U.S. Attorney's Office. But in our case that we filed, service ended up being a little bit trickier, and so we executed service by hand delivering on the U.S. Attorney's Office and then also just certified mailing to all other named respondents. And again, just be ready to move quickly or agree to some sort of briefing schedule, because it's typical that the courts within a week of receiving this kind of petition, or even within a matter of days or hours, will order a status conference. And so we'll open it up very shortly to questions. And I know that hopefully one of them that you have is, how can I help during this time? And so we would recommend first signing up to be a volunteer attorney with the ACLU of Hawaii. We are launching this new program for you to hopefully be able to partner with us in filing habeas petitions and other sorts of legal actions that we do the work of here. Well, I know you might think of the ACLU as a huge national organization, and it's true. We have a huge national office and then folks as far as Massachusetts and Puerto Rico. But here in Hawaii, we have 3 attorneys, 1 legal fellow, and 1 paralegal. So, we're a small but mighty team, and we could really use your assistance in pro bono work going forward. So there's a QR code for that. And if you think, hey, maybe now is not the time, I'm also slammed with all of my work under this administration or just generally, we would encourage you to sign up to be an ACLU member. Every year we start from 0 and we raise funds to continue our work and keep our staff. So becoming a member supports us to continue to do the work that you've seen us do out in the community and here in our islands. So we thank you so much for coming to today's presentation. And I'll go ahead and keep sharing for now, but open it up to questions. I know that we might have some in the chat, but feel free to raise your hand and we can take those in order as well.